President Biden has said that he's not confident that the Supreme Court will clear his student loan forgiveness plan.
Why put in the horizon of the right side of the law? Well, I'm not confident about the outcome of the decision yet.
Well, the majority conservative court weighs the case. The Supreme Court heard arguments earlier this month on the student loan plan, which is set to forgive up to $10,000 for student loan borrowers making $125,000 or less. The plan could also forgive up to $20,000 for borrowers who took out Pell Grants to go to college, but the plan has received multiple legal challenges since it was first introduced in August. President Biden and the White House have expressed confidence in their legal authority in order to implement this plan through executive action, and the White House recently has shied away from talking about an alternative or a plan B to the plan if the Supreme Court does decide to strike it down. The U.S. Solicitor General has represented the Biden administration at the Supreme Court and is working to fend off these challenges, which come from 6 Republican-led states, as well as separate challenges from 2 individuals. The question that will likely decide the fate of the president's student loan forgiveness plan is if Congress clearly gave the executive branch the authority to forgive debts through what is known as the HEROES Act.
The whole point of this statute, its central mission and function, is to ensure that in the face of a national emergency that is causing financial harm to borrowers, the Secretary can do something. He can alter the student loan program to ensure that they're not worse off. So there's not the same mismatch here of taking an old statute and dusting it off and deploying it in a context where Congress could never have imagined it would be used before. Instead, this is a perfect fit with the problem that the Secretary confronted.
Nebraska brought this case primarily as a separation of powers case to be able to protect the Constitution. It wasn't about just student loan borrowers or people who didn't receive the relief. At the end of the day, it's about the citizens of this country being able to have their voices heard through their elected representatives.
Missouri is integral to this case because of the state program that's a creature of state statute that administers student aid financing under state law. And so we feel confident that the justices latched on to the right issues during oral arguments. Specifically, they identified the lack of fairness in the process.
If a program like this is going to happen, if nearly $500 billion is going to be canceled off the federal government's balance sheet, that's something that should come through Congress.
The Biden administration has tied the relief to the emergency established during the COVID-19 pandemic. And this may not be resolved for a few more months. The Supreme Court decision on the case will likely not come out until maybe June, which is typically when the High Court gives its decisions on its most controversial cases.